Hi, and welcome back to Hill and Ponton's YouTube Live channel. My name is Allison Reddick. I'm one of the attorneys, and with me, I have former Marine, VA-accredited agent, and former VA employee, Kerry Baker. He just came back from the NOVA conference. How are you doing, Kerry?
I'm doing pretty good. How are you?
Good. So what we're going to do is we're going to start with some questions in the community section, and then we'll go over to the live questions. So off the bat, my BVA judicial review has been on judge's desk since October 2020. Any idea how soon this may get settled? No, first of all. But honestly, the reason that there is so much delay is because we learned that at the conference, there are about 114,000 pending legacy appeals. 80,000 are at the board and around 20,000 are at the regional office. That date that you mentioned, is that the date that you had your hearing? Because even if you had your hearing, that doesn't mean you're going to get a decision soon. It's all dependent on the filing and certification of your VA Form 9 to the board. So everything goes in order. And legacy, although those are the claims that they are taking precedent to try to get rid of those, if there's advancement on the dockets before it, those are going to take precedence. And we have this huge backlog, as well as adding the AMA claims. Any other information you have on that, Kerry?
Always stuff on the board and how long things take and why they take a long time. VA would never, probably could not give you very many straight answers on that. There's a lot of factors that we don't like as a firm and as individuals. One problem in that part of the system is, and not here to knock on BSOs, but I'm going to knock on BSOs a little bit. So they have been requesting hearings in almost every single appeal. It's very easy for them to get work off their plate, to put it back on the board and just wait for a hearing. But the result of that is somewhere over 60,000 hearings pending at the board. So if you've requested a hearing and an appeal yesterday, for example, you're going to be waiting a long time. But we don't even have those figures because the board doesn't even know how long that could be waiting. If you had a hearing request in for 2 or 3 years, yeah, so you're probably getting pretty close at this point. So that's another thing. One thing that nobody likes, and most people probably aren't aware of this, if you have an AMA appeal that's been remanded by the board and then denied on remand, and it goes back to the board, which you have to initiate a new appeal on, that appeal now goes to the back of the line when it goes back to the board. That did not happen in the legacy process. None of us like that. VA did that in a regulation. The statute that Congress passed did not require that. There's a lot of people upset about that. And stand by. Some of us are trying to look for ways, things to do about that, but whether we can or not, we're just not sure yet. So if you've got one of those situations, your appeal is going to take probably just as long as it took the first time to the board. And that's unfortunate.
Yeah, I know that there was a time in COVID where the board was opening up hearings, and there were people that only had their VA Form 9 or their AMA DRR waiting for like 6 to 9 months, and they had a hearing and they're like, okay, I'm going to get my decision. But it doesn't matter. Like, even if you had your hearing then, that was a mistake. They weren't supposed to do that. And you won't get your decision until your docket number comes up. So wherever your docket number is, and usually it's based off of the date, it is the date that you filed your VA Form 9 and it was certified, that you have to wait for everyone in front of you. And what makes it even more difficult is BVA is a separate entity, and it's judges and lawyers, and they don't have just email addresses that we can email and try to hound them to get responses, where at the regional office, we have a little more leeway with that. You kind of have to do things on their terms, and when they make a decision, they'll make a decision. But hopefully they are really trying to get rid of as much as the backlog as they can in the next 2 years. So hopefully sooner rather than later, you'll have decisions. Okay, next question from the community. Why does the VA hire outside vendors to do CMP exams? They don't do a good job at all. And my last one, the doctor never even looked at me, in and out. How could they possibly make an educated, fact-based decision in that fashion? Total waste of time and resources. Gary?
Well, you explained VA exams pretty good. This is a sort of a pet peeve of mine, has been for a long time, and probably will be for a very long time. This is, in my opinion, the single worst part of the claims process, and for all the reasons you just mentioned. Now, why private vendors do that? VA a number of years ago got approval through Congress to use private contractors. They liked how that went. The private contractors could get the exam done a little faster and somewhat more efficiently. And they had lots of goals, in other words, with that process. And they've since expanded it to where just about every VA exam for compensation or pension purposes is done by a private contractor, either LES, QTC, or VES. Did I say all those right? VES, QTC, and LHI. There you go.
LHI.
And they're all over the country. Now, VA can still do exams through the VA medical centers, but those are now kind of limited to specialized exams. These exams are terrible, but they were just as terrible when VA did them. The medical opinions are all the wrong legal standard. I mean, it's just, there's the list of what's wrong with them, or we could make a week's worth of videos just on that stuff.
So basically, they chose to do it for time and money, to speed things up, to spend less money. They are bad, but if you've seen my videos with Dr. Benitez, he's a contracted CMP examiner as well. Some of them are good, majority of them are bad. And make sure when you ask for a copy of your exam, look up the credentials of the examiner. I just had a horrible knee examination that I saw, and the doctor that did it was an OBGYN. Why is an OBGYN doing a knee examination and determining service connection for that? So definitely be on the lookout for that. And that's kind of the good part of the AMA system, is the higher level review. If you do choose that, you can say like, look, they didn't look at me. This was a bad examination. This isn't even the right specialty. Can I have a new exam? Or, I mean, always try to get an outside provider if you can get one of your providers to do it. Okay. Can I or should I submit for secondary with back issues while I wait for them to schedule my BVA hearing? Been waiting years. If your BVA hearing is for service connection for your back and you have issues secondary to your back, absolutely go ahead and get that effective date. Things like radiculopathy would be an inferred issue and they may be included, but I wouldn't depend on VA to make that determination. I would say go ahead and file things. What do you think, Kerry?
No, I agree. There's a lot of misinformation out there about, you've got something pending, don't file anything to mess it up till that one's done. And I don't agree with that. Now there's smart ways to do it and not so smart ways to do it. You want to stay away from the notion to be a chronic filer, if that makes sense. Don't be filing claims every couple of months and every year. I mean, figure out what you need to file for and try to do it at once. Now, obviously that's not always possible. Something might happen tomorrow that you didn't have a diagnosis that you had yesterday, and it might be something you could get benefits for. So that would, legitimize another claim there. But if you're going to have residuals and secondary issues, get those claims in as early as possible. It preserves your effective date. It's not going to mess up whatever else is on appeal, because those are all they're different stovepipes now. So yeah, get the stuff in as early as you can.
Yeah, I agree. Had an appointment and completed the aid and attendance form, but my social worker submitted it and it got denied. Is that normal? I never asked them to submit the form and VA won't give me the form. Well, you can find those forms online. I'm pretty sure they released that. You can just Google VA aid and attendance form and you can find it. But normally for aid and attendance, I would have a doctor fill it out. If it was a social worker and you have a mental health condition, they don't really see high standard with the social worker's opinion, I would try to get a psychologist or a psychiatrist. Kerry, what do you think?
No, I agree. Yeah, if you want to look up the form number, it's VA form 21-2680, or you just punch in 2680 in a search window on va.gov. You should get the form. If you want the form that they submitted, they have to give you that. If you request a copy of your records, I mean, they can't withhold information from your file. They might be a little pain in the butt to get it, but they can't tell you you're not allowed to have it. As far as the denial goes, yes, that's common. Denial on many things are common, but yeah, I agree with everything Allison said.
Good afternoon. I filed a claim for anxiety secondary to sleep apnea and was sent for a CNP and had a good response from the examiner, but I had forgotten I filed anxiety as a standalone back in 2014. So are you service connected for anxiety? If so, then it is potential to get a sleep apnea secondary to that. PTSD, anxiety, a lot of the mental health disorders there's research out there showing that it is secondary to that. However, that's not something they're going to prove 99.9% of the time at the regional office. It's something you're most likely going to need a medical opinion for, but you're also going to need the anxiety to be service connected prior to that, unless you had sleep apnea symptoms in service. Have you had luck with diabetes secondary to PTSD? I mean, I definitely think that is possible. If you, because of the way your body responds to things, I would think PTSD could lead to hypertension, which could lead to diabetes. Kerry, what do you think?
I'd be a little skeptical, but every case is different. So I wouldn't want to paint with a broad brush and say, yeah, go out there and file these claims all over the place. But some person's PTSD is going to affect them differently than somebody else's. It might change your eating habits, where it might be more prone to, you might eat and eat the wrong things as a form of self-medicating your mental health issues, end up with diabetes. I think it's going to be hard probably to prove that kind of case, because most VA employees are going to look at it and just initially think, well, a mental health condition is not going to cause diabetes. And they're probably right in most situations, but if you've got a unique circumstance about your case and can make that connection, then yeah, go ahead and give it a shot.
Yeah, what you need is if you can get your doctor or someone to show the research and look at your claims file and show how medically it can be connected, you have a shot. But if you're going to file that, VA examiners are not going to connect that.
Right.
I recently received a denial for service connection for hypertension. I was in Persian Gulf War 1990. I think probably besides tinnitus and hearing loss, hypertension is probably one of the most requested condition to be service connected. Would you agree with that, Kerry?
Yeah, probably so. It's certainly up there pretty high.
Yeah. So usually when it's things like that, it's even harder to get service connected. Persian Gulf War syndrome, anything like that, is there association with that in hypertension?
Yeah, I'm kind of hesitant to get into Gulf War stuff, but because it can be its own topic. Typically, though, you're going to look kind of speaking broadly, you're going to look for two different things when it comes to Gulf War: either an undiagnosed illness or a medically unexplained chronic multi-symptom illness. You're going to have a hard time showing that the hypertension is either one of those. Now, the undiagnosed illness is simply not going to fit into that category. The medically unexplained chronic multi-symptom illness, by definition, that's a diagnosed condition with unknown etiology or pathophysiology. So, and that's a case-by-case basis, but VA gets that wrong almost 99.9% of the time. Would it be a medically unexplained multi-symptom illness? I would have a hard time seeing a VA doctor is not going to say that it is, going to say that, hypertension can be caused by being overweight, wrong diet, genetics, and in some of those situations, that's obviously going to be correct. So I probably wouldn't run out and file that claim in that manner unless there were something else that you could link the hypertension to directly, like another type of exposure, that you can show on a direct basis rather than a presumptive basis, or another disability that might be aggravating it. So that would be a tough claim.
Also, ask for a copy of your service medical records. I mean, if you've had hypertension, there could be notations of high blood pressure in service, or if you were on medication for hypertension in service, look for that, because then you could get direct service connection that way. And that's going to be way easier than Gulf War or anything like that, because there's so many symptoms associated with it, and it's hard to get that undiagnosed illness due to all the rule outs. Secondaries denied. VA ignored claimed weight as intermediate step. Is this a cue or a duty to assist failure? Chances at HLR. So basically, you're correct. Weight, I mean, obesity is considered an intermediate step. So let's say that you have diabetes and you become obese, and then that leads to you developing knee issues or orthopedic issues, things like that. You can't claim obesity on its own, but it can be a step between two conditions, or it can be in a sense that if you had obesity, it made you develop these conditions. However, that's not a cue. I would say that would be a duty to assist in a sense, but I don't think you're going to have great chances either way. You've got to explain why it's an intermediate step, and it's hard for me to give an opinion without the other conditions that are on other sides. Do you have anything, Kerry?
Well, it's definitely not a cue, like you said. Duty to assist could be, depends on the case. If you were clear in how you filed the claim, and that you were using weight gain as an intermediate step between a service-connected condition and a non-service connected condition, and VA overlooked that, and maybe they got an exam and an opinion that did not discuss the weight gain. So, there you have a situation where you told VA what the theory of entitlement is. They went out and developed the case, but maybe just didn't ask the right question. And so, yeah, you could argue that's a duty to assist error, definitely not CUE. If, on the other hand, you just file a claim and don't provide a basis of the theory of service connection, there might not be a duty to assist error there if they didn't otherwise know to ask about the weight gain as an intermediate, or if there may be no duty to assist error, and they may just be a negative opinion that's adequate for rating, and you're going to have to fight that with another opinion. So that wouldn't be a duty to assist error. It's just that's just a fight.
I was given the anthrax vaccine in 2000 and have adverse reactions to it. I also understand 2 million doses were not FDA approved. What are my options to file a claim for anthrax? Well, you wouldn't be filing the claim for anthrax. You would be filing for whatever adverse reactions or conditions that developed secondary to it. But anthrax vaccine and these newer veterans, that's an interesting one, especially if they weren't FDA approved. Do you know anything about anthrax vaccinations?
Yeah, I've seen claims like that. Obviously, I think those are exceedingly difficult. Unless there are things that happen to you almost immediately after that vaccine, I file the claim if you can make the case for it, obviously, but just be aware those are very difficult claims. If you had a vaccine and had no reaction to it, and you filed the claim 20 years later because you were diagnosed with something last year, the odds of getting that secondary to a vaccine are almost zero. So just keep that in mind.
When I file for an HLR, should I ask for informal conference or submit written statement? Does HLR recognize intermediate step claims? We talked about the intermediate steps, but for HLR, it really depends on the issue. You can do either, you can do both. I would definitely say put a written statement in there to explain why your theory is what it is. But also sometimes for informal conferences, I like to do them if it's something like an effective date issue where they went to the date of the 8940 instead of the initial claim, things like that. But a lot of times at the regional office, if it's something more complicated, their hands are tied in a lot of senses. And if it's toxic exposure and things like that, you're most likely going to have to go to the board. What do you think, Kerry?
No, I agree. I agree with everything you said there. I don't think I have anything else to add to that one.
Okay. Does 38 CFR 3.317B, number 11, show cardiovascular signs or symptoms? And is hypertension a cardiovascular sign or a symptom? I don't know the answer to that.
Yeah, I can answer that.
Okay.
It is a sign or a symptom. I mean, hypertension is cardiovascular in nature, but that does not mean, hypertension is a diagnosis more so than a sign or a symptom. So I think it's kind of semantics at this point, but it doesn't mean that hypertension would make a good claim under 3.317 for the reasons we discussed before.
Requested my C file over 6 months ago and still nothing. Why does this take so long, and what can be done to speed up the process? I mean, because it's a FOIA request and it's the government. The government likes to take a long time to do things. I mean, I've seen it take over a year to a year and a half to get a claims file. I don't really know if there's anything to speed up the process. They stated above, okay, back to 3.317 as a reason for denial. I would say they made an error in that they should have presumptive service connect me for hypertension based on that. Please clarify. Really know what you're asking.
Well, I can, if you need additional clarification, I would say probably send us I'm not sure if we already answered that question or not. But yeah, hypertension, because it's not undiagnosed and it's typically not a medically unexplained chronic multi-symptom illness. For those two reasons, VA is usually not going to grant presumptive service connection for it. Probably never grant presumptive service connection for it. So, I mean, that's really the bottom line there.
Does VA give ratings for flat feet? So it's pes planus, they do. It depends on the pronation and different features of your feet, but you can get a rating for that. I think that I've actually seen, normally I will see a 10% rating, but I actually saw someone recently that had 50% rating because it was a very serious foot condition. But yes, they do. You can get a rating for flat feet.
You could even go up to loss of use in very rare circumstances. It'd be pretty severe for that to happen, though.
How do you get bilateral factor rating? I filed twice for it and nothing. Is it listed on your award sheet? I'm radiculopathy 20% both arms and 20% both legs. So that should be added in and it should be on your rating sheet. It'll say that the bilateral factor is listed on there. I haven't seen where they've missed that. Have you seen them missing that before?
I've seen them miss it, but the one problem that this person's likely having is they don't get a copy of the code sheet. So if you don't have a copy of the code sheet when VA sends you the rating in the mail, you're not going to see that they've applied the bilateral factor because it's on the code sheet. It's not an issue in the rating decision itself. So when you say you filed for it, it's not something you need to file for. If it's on the code sheet, it'll tell you, what codes they use to get to the bilateral factor and what bilateral factor that they actually used. So you need the code sheet and you'll probably see it on there. Now, if it's not on there, then you've got, and you've got a compensable rating of two opposite extremities, then you've got an issue. Then you can come back with them and that, but that's not a claim. That's not per se. I mean, you could appeal it if they forgot it, but it would be just kind of notifying them that they made a mistake and they need to correct it.
Also, if you know your combined rating, it's usually listed on your NOA. You can go to our website. We have a link on there where you can go and include it'll automatically do the bilateral factor for you. So you'll do like left arm 20% and then right arm 20% and then left leg, and it'll include the bilateral factor for you. So you can see if your current combined rating is correct or not, but also try to get the rating sheet. I recently got 60% for my hip replacement. How soon is or should I file another claim for a chronic lower back pain that was related to my hip, which is service connected? I would say if you're service connected for your hip replacement and you can show chronologically that you had that hip disability for so long and it affected your gait and how you walked, then absolutely that could affect your back. Sometimes you can get that in a C&P examination, but most likely you're probably going to have to get an outside provider, whoever did your hip replacement or any orthopedic doctor, to say, because of the hip, it affected his gait, which affected his back. And then you could get a secondary condition after that. I don't think you have to wait. Since it's already service connected, the primary condition, I would go ahead and file for it, but you have to know that it's going to be more difficult to get unless you have someone providing a nexus opinion to show that system of how the chronic lower back pain resulted, and that you have to have an actual diagnosis of it. You can't just have lower back pain. You have to have a diagnosis of it. It can't just be a symptom that you have. Kerry, good one for you. What types of claims are there for sinus issues? If you don't know recently, and we've talked about it a lot, there are new presumptive conditions for Gulf War veterans and veterans who served after 2001 for sinusitis, rhinitis, and asthma. I know for sinusitis, you have to have obstruction, and then to get a higher rating, you have to have polyps, right? I think.
I mean, to get to the rating, they're going to look at percentage of obstruction in your nasal passageways, polyps. Do you have any surgeries, that kind of thing? But you're absolutely right, Allison. The three things have been added. So if you've served in the Gulf War from August of 1990 up to the present, or in Afghanistan post 9/11. You get any of those, then you can get service connected now. Now you do need to have manifested those conditions within 10 years of the exposure. Most of the time, if you're going to have like a burn pit related sinus problem, it's probably going to show up within 10 years. So I'm assuming that's what the basis of the question was. Otherwise, that's not the basis of the question, if you had frequent colds and hay fevers and things like that in the service, and that never went away, then you can file a claim just based on the current condition beginning in the service as well, just like any other claim.
Kerry, this question is directed at you from Michael. Kerry, I found new evidence for CARC exposure to polyneuropathy. VA has known about it for 30 years. I think I have a class action potentially and already called in about it. CARC exposure. Can you explain that?
Well, to the extent if you have a class action, it's probably not something I could give an opinion on there, just based on a question like this. But yeah, CARC paint, trying to remember what it stood for, but it's basically paint that was used in the military on all kinds of different vehicles, like infrared or some kind of special paint. I'll think about it.
Chemical agent resisting coating.
There you go. Chemical agent resistant coating. And you're right, it does. It's nasty stuff. It does not surprise me that you found something related to polyneuropathy. It used to be a bigger issue a number of years ago than it's been lately. We used to hear about it all the time, probably 10 years ago. And if I say in the past 10 years, we haven't heard about it that much. I'm not really sure why. But yeah, that's a legitimate claim if you've been exposed to it. But it's an exposure claim like other exposure claims. Those are tough. VA employees now, right now, probably have never heard of CARC paint. A number of years ago, they probably had. So, it's going to take some legwork to get a claim like that through. if you can get it through.
James H. retired in 2016 and did not claim seizure disorder 2010 on initial claim. Can I file it now and take my 90% to 100%? Yes, you can file it now. Was this something that developed in service? Is it noted in your service medical records, or did something happen in service to cause you to develop the seizure disorder? Of course, you can file a claim for it to get to increase your rating, but you have to make sure you meet those elements: current disability, incident in service, and a nexus opinion. Anthony Lindsay, all I can say is get an attorney. Yeah. Okay. J, filed for PTSD and anxiety. If they deny my PTSD, does that mean they will deny my anxiety as well? I was diagnosed with anxiety in service. So even though you're claiming for PTSD and anxiety, you only get service connected for one mental condition. I mean, sometimes they'll say service connection for anxiety claimed as PTSD, all of the other things. There are different standards that you have to meet for service connection for PTSD than there are for anxiety. For PTSD, there's a different form that the examiners fill out, because you have to have a confirmed stressor for the PTSD diagnosis, and you have to meet all of the criteria for PTSD. So a lot of times when you claim PTSD, you'll meet the stressor criterion A, and then they'll say you don't meet anything else, but they will diagnose you with anxiety disorder. And what they're supposed to do is then go back, and if you have something that happened in service, they're supposed to go do the mental health CMP examination form as well, which is a different standard. So if you were diagnosed with anxiety in service, I mean, that could still be anxiety now. If you had a stressor that met criterion A in service, I mean, it could be PTSD. I don't think that just because you're denied for PTSD means that they'll deny you for anxiety as well. It really depends on if they do both types of the CMP DBQs that they're supposed to do. Kerry, do you have anything to add?
No, not really. Yeah, but one doesn't foreclose the other. And if you had one in service, that's a strong case right off the bat, in my opinion, especially if you still got it now. So yeah, not really anything to add. I think that was a good answer.
From Hobie, does your diagnosis for mental health need to be from a VA doctor? Can it be from your civilian primary care facility? So you can have your diagnosis from your primary care doctor, but VA is still going to go and do a compensation and pension examination and get their own opinion. And usually from there, they'll say what they think your mental health diagnosis is. However, at the end of the day, your doctor is, primary care, that is a doctor, and you should be fine. But if they come back with a psychiatrist or psychologist, then that could make it a little more difficult, because then you have a specialist giving their opinion compared to a primary care doctor. What do you think about that, Kerry?
I think you covered all of it on that one.
Okay, Anthony Lindsay, I am good. Thank you guys for representing veterans. Well, thank you all for your service. We appreciate that. Jeff Blackburn, can you claim multiple service connections for a secondary condition? For example, I have plantar fasciitis when trying to connect this to service. Can I claim it secondary to bunion and ankle and back? I like the example. So basically you're saying that instead of getting it directly service connected, that you had other issues that are already service connected, which would be bunion and ankle and back. Can you get the plantar fasciitis secondary to it? I think the bunion potentially, the ankle plantar fasciitis, where is that? I think it's possible. What do you think?
I was trying to follow you, but I couldn't quite find that question. So
basically he's trying to get plantar fasciitis, and instead of direct, can he claim it secondary to bunion and ankle and back?
Yes, I mean, for as far as the back goes, I don't know that a back condition is going to cause plantar fasciitis. But I mean, as far as all the mechanisms of the ankles and below go, to the extent that there's medical evidence that, one caused the other, one aggravated the other, yeah, sure, you can file a claim for it. But it's going to need to show just that, some form of medical evidence linking one to the other, either directly or through aggravation. But yeah, well, I would think when you've got multiple foot conditions, that one could possibly aggravate the other. I don't see why it wouldn't, but just use common sense, okay, when doing this. I've seen things like somebody's claimed a shoulder condition secondary to a toe. At some point it gets to where they're going to look at that case somewhat in negative light right up front. So don't give them that opportunity. Now, if there's obviously you had an amputated toe and it was service connected and it was causing you to fall and you fell and broke your shoulder, and you can show the link between one and the other. Yeah, that's a doable claim, not an easy one. But it's absolutely a valid claim as long as you can link it medically. But just do some homework first.
And if you can get a doctor to link it medically, I mean, right, depending on these VA examiners to provide that opinion is very unlikely. But if you have your doctor who will come in and write a statement and say, and explain the medical causes behind it, you're going to have a much better chance than just depending on the VA examiners. Okay, Gregory Harper, 73 years old, 50% sleep apnea, 80% total, retired for 6 years, filing for inferred IU based on falling asleep during the day. Chances. I think it is difficult to get IU solely based if your main issue is sleep apnea. I don't think it's impossible though. If you have the medical evidence, if you have doctors saying, you're falling asleep all the time throughout the day, you cannot maintain a competitive job. Also, what are the other conditions that you're service connected for going up to the 80%? Are they orthopedic issues? Do you have a back issue where you can't sit? I mean, that's going to be ruling out sedentary employment or knee issues, mental health issues, things like that. But a lot of the times I do see it is more difficult when your main issue is sleep apnea. However, it's still possible. It just depends on the evidence that you have to support it. What do you think, Kerry?
I don't think I have anything else to add to that.
Okay. The bounty. Oh, I just lost it. Where'd it go? I know it said something about, I want to file a claim with Hill and Ponton. How do I do this? So you have to call and go through our intake department, and you have to have a current rating decision that, has been within the last year, unless you're like a Blue Water Navy veteran and you're trying to reopen things like that. So you go through our intake department, then it goes through, if you go through that, then you get to our managing attorney, a partner, Matthew Hill, who'll go through and look and see if it's a good case to take. Oh goodness, I don't know. Okay, here we are. Jeffrey Purcell filed secondary mental health to primary connected. Bad CMP, complained and wrote a letter. Now it was sent to another CMP exam, but just for review by another doctor. I cannot attend this. Is this normal? I do see that a lot where they'll ask for another CMP examiner's opinion, but it won't be another exam completely. So they'll basically review the record and make their decision based on that. Do you see that as well, Kerry?
I have seen that before, and it can be problematic. If it consistently turns out against you, it's just one of those situations that you may just have to develop your own evidence, unfortunately.
Okay. I keep adding questions and I'm losing my place.
Yeah, I'm trying to keep up with you.
I think I jumped a little because it pulled me, but let's see. Oh, let's see. Michael says 4 neurologists, 3 who have been studying a golf vet for 30 years due to CARC work for VA in Orlando. They know polyneuropathy is caused by CARC. That's interesting. If you know the doctor's names, I'd love to know that and see what research they've done on it. Okay, Wendell. Don't know why the VA stopped during Nexus letter. I'm retired, can't afford outside doctor, am on a fixed income. I use the VA for care. Can you help with that? Potentially, we could help with that. Depends on the facts of your case. I would send it in and have intake review it. Is that time? Can PTSD 100% cause secondary hypertension? I think so. I definitely think that if you have severe PTSD symptoms, it affects your other body symptoms or your other body systems. However, that's something that most likely isn't going to be granted without a medical opinion to show the medical research behind it. Hi, it's Shim Howard. Hi, submitted secondary radiculopathy claim to my service-connected cervical strain DDD. Sent in a DBQ from surgeon and an EMG from neurologist. Does VA routinely grant this without a nexus? They're still probably going to do their own C&P examination to show that the cervical strain is what caused the radiculopathy. Is it radiculopathy of the upper extremities? Because then that would make more sense. Lower extremities would be more difficult because it's lower in the spine, but definitely for the upper extremity radiculopathy, that's something that makes sense. The evidence should show that, especially if your surgeon commented on it and said that the radiculopathy is secondary to the cervical strain, then that should be fine. But always 99% of the time, if not 100, VA is going to get their own exam. Okay, let's see. Robert Ramirez, routine exam this August for service-connected both hips. Do you recommend doing a DBQ with a private doctor? Don't trust C&P examiners. I'm 100%, but not PNT. This is the only condition, not static. You're having a routine exam. You have to go to that if it's through the C&P. They're doing the routine exam because you're not PNT. And if you don't go to that, that could really mess with your ratings. I know the C&P examiners aren't great, but you always have to go to your exams. But absolutely, I would recommend getting a DBQ with your private doctor to refute anything that examination says if it's anything negative. It's that time. Can service-connected sleep apnea cause secondary hypertension? I think so, yes. I think that the way the sleep apnea affects the blood flow throughout your body definitely can cause hypertension, but that's another one that is going to need a medical opinion.
And I agree with that too. I've seen medical opinions linking spikes in hypertension to sleep apnea for that same purpose, because while you're going through that apnea, your heart's working harder to get that blood everywhere. And that's one of the reasons they want people on medicine or CPAP or whatever the case may be, is the long standing residuals of sleep apnea, can be relatively severe when you're talking about cardiovascular disabilities. So that's the biggest reason to get treated for sleep apnea is not, obviously you're tired during the day, but you don't want to have a heart attack at 50 years old when all you had to do was treat the sleep apnea to prevent it. So
absolutely, we've had vets that had sleep apnea in service and they developed hypertension, heart disease, diabetes. We were able to get all of them service connected secondary to it.
I have seen in one situation, very rare, it surprised me, a VA examiner, that's why it surprised me, because it was a VA examiner, pulled out blood pressure spikes from the veteran service medical records and used those as an example that early on, onset of sleep apnea is going to cause blood pressure spikes. So it would account for why that veteran might not have had a diagnosis of hypertension in the service, but may also account for why there were elevated spikes here and there, because the sleep apnea was initially having its effect on the body. So I've only seen that one once.
See, and there's proof that you can have a good C&P examiner. Far and few, but it is possible. Okay, Audria Wilder, filed for headaches, was denied. It's in my service records. How can they deny claim? So having it in your service records absolutely helps, showing that you had that condition in service, but how long after service did you file for that claim? You file 10 years later. If so, you have to show that continuity of care, because most likely they're going to say, yeah, she had headaches a couple of times, but on her exit examination, no issues, and it wasn't caused by service. So that's potentially why they denied it. You have to show that even though, yes, I had headaches in service, exit exam, most people just want to get out of there and don't even say if they do have issues, but then you show treatment records since after service or lay statements from you or family members to say, yeah, she continually had headaches after service. And that's how you prove that. Okay, Bobby Moore. Hi, hello. I am 80% with 40% for TMJ. Wow. Having more issues with mouth and jaw, going to see a TMJ specialist at VA hospital. Can I get my TMJ increased from 40%? Oh, I don't know what the maximum rating is for TMJ. Do you know the maximum rating for that?
Not off the top of my head, but if I could still add something to that question. So that I agree with Allison. That's a good rating for TMJ, but that's also a very good reason to think twice before you go filing for an increased rating. Not saying you won't get it. I don't know the facts of the case, obviously, but you probably know by now one way they rate TMJ is like interincisional range of motion. How far you can open your mouth, for lack of better ways to put it. And sometimes you have better days than others, particularly with other parts of the body, that's for sure. Or it might be of how the examiner reports it. So you wouldn't want to get into a possible reduction simply because an examiner is reporting it in a way that may not be accurate, or you might be examined on a better day than another day. Just keep that in mind. If you are, you are certain there's no chance for a reduction, and look at the overall benefit. What if you're already 100%? I wouldn't mess with it because it's not going to make a difference.
80%.
Okay. Oh, 80%.
So basically for TMJ, looking at that, it depends on what your maximum unassisted vertical opening is. And it's like 0 to 10 millimeters is 1. And the highest you can get overall is 50%. You may be at 21 to 29, but then it goes from there based off of your dietary restrictions. So getting that additional 10%, it's not going to increase your rating to the point where you're at 100%. So I probably wouldn't do it. I don't know the facts of the case though, but like Kerry said, going back then and having more hands in your file is putting you at a point for reduction. But I mean, you can also go to your doctor and have them do that maximum unassisted vertical opening and see what it is. And then if you do have dietary restrictions, I mean, but they're pretty intense with dietary restrictions to all mechanically altered foods. That's how you get to a 50% rating. Okay, let's see. Acacia Baldonado. I'm currently in appeal for major depressive disorder. Will I get a CMP exam automatically? I'm waiting for the judge to decide. If you're on appeal, then, okay, so basically if it's a claim and you have evidence of a current condition and they find something in your records to show that you have cause to have major depression disorder or you had a diagnosis, then that should create cause for them to give you a CMP examination. But it's not always necessarily automatic, but you would know if you had it or not because they would give you a denial if they didn't. If you're appealing it, then it's being reviewed by someone else to a point where they could give a duty to assist error if you had an exam or not, but it sounds like you may be at an initial claim. I'm not really sure about that one. Okay. Oh, this is an interesting one. I would like to know your opinion on, Kerry. Jose Alberto, because I see this all the time. 100% PNT, have PTSD and TBI combined into single rating, 70%. Should I file a supplemental claim to get separate ratings for PTSD and TBI? I don't think you should if you have 100% permanent total, but I am interested on your opinion about when VA puts TBI and PTSD together. You can get those separated out, but I mean, it's hard. What have you come across on those?
I think one like that approach with extreme caution. Yes, they can rate TBI residuals separate and distinct from PTSD. And obviously you get the right kind of TBI or the wrong kind as it may be, you're going to have physical residuals. Those should not be rated with any mental health criteria. But when you're talking about a cognitive problem resulting from a TBI, that's where you're going to start seeing some overlap into the mental health criteria. There are ways that a cognitive issue can be rated separate, but you're really getting into the weeds, and you're going to have to be able to show, or a medical examiner is going to have to be able to show, your cognitive problems as very distinct and separate from your mental health problems. And sometimes that is almost impossible to do because a mental health problem can cause, cognitive-like problems. With the TBI, however, it can be more of an organic issue rather than, just related to mental health issues. So be very, very careful on that. If you think you want to file to get separate ratings, and the majority of, I think the separate rating you want to get is dividing those two up and hoping to get something extra like, a housebound rating with 100 plus 60, I would be really careful then. In fact, I probably wouldn't do it unless you're protected at 100%. Once you're protected at 20 years consistently at that rate, you're not in any danger of getting reduced at that point. But if there are lots of physical residuals, then obviously that's going to be a fact-specific scenario, and you might want to. But if you're really just dealing with a mental health and a cognitive issue, all resulting from the TBI, and you're 100%, I might leave that well enough alone without knowing more of the facts of the case. Obviously, there's going to be those situations where the collected picture, rather than the individual pictures, are going to support something like a housebound rating or aid and attendance, something like that. That might be a little bit better to look towards than trying to separate those two out. But again, it's facts specific, it's case specific. So I would approach with caution, and I would not do anything if you're not protected until somebody that can be objective with you and honest with you can maybe take a look at it, and tell you what kind of danger area you're in. And I say that with a grain of salt, because I usually don't tell people to go out and start at it, because most of the advice you get is just wrong, even if it comes from senior BSOs. I just be careful with that.
And I mean, 100% permanent total, and I don't think you really need, without knowing the facts, to separate it out, because if you're having issues where you need aid and attendance, you don't have to have one condition that's 100%. You can use that 100% combined to get that aid and attendance. With TBI, if it gets to a point, you could get,
SMCT.
SMCT, which is like the highest compensation you can get based on, I mean, that's like if you need nursing home care, but you have someone taking care of you due to your TBI residuals. So going off of that with the, oh, you want to say something else?
Well, yeah, if I could add to that, we get a lot of cases where a vet has a TBI and maybe they're 100% through unemployability or something like that. And they come to us and I want SMCT. SMCT is not easy to get. I want everybody to know that. Just because you have a TBI and you might be rated 100% does not mean you're going to qualify for SMCT. Because remember what SMCT is. It's a much, I say much, it is a much higher level of aid and attendance. I mean, that's what you're going to have to prove. So if you have a TBI and you cannot get to aid and attendance, the regular aid and attendance, right? You can rest assured you're not going to reach a higher level of aid and attendance. And that's what I tell everybody when we're trying to get SMCT for folks. If we cannot establish that you need aid and attendance, the regular aid and attendance, there will be no way we can establish that you need a higher level of that aid and attendance.
Absolutely.
And that higher level has to be done by medical experts where without such assistance, you need to be institutionalized. That's not easy to show. It's very rare cases there. But for those that do have that severe of a TBI, that is an outstanding benefit. It can be gotten, but if you've got a PTSD and TBI mixed together at say 70%, and that's relatively accurate, you're not working, but you can function, you're probably not going to get SMCT.
Absolutely. I think I've seen like a handful of SMCT grants. I mean, that's a lot of money. So they're going to be very strict on who gets that and determine that they really need it. And you're going to have a lot of medical evidence. But I mean, I think Kerry's point that you definitely have to qualify for regular aid and attendance first before you can even think about getting up to SMCT.
Yeah.
Okay.
I got one a while back. Briefly, I got one a while back. SMCT. This guy took a bullet to the head in Vietnam. He was paralyzed on half of his body. He was spastically paralyzed on the other half of his body. He had a lot of Agent Orange related issues. He was SMCO and had been reduced because VA thought they made a mistake. They counted something twice. What they forgot was he had a bullet to the head and thus qualified for SMCT. And so, we got SMCT in that case, but think about that: a bullet to the head, loss of use of 2 extremities, almost loss of use of all 4 extremities, and a bunch of other things going on. So that's and it still took a fight and getting down into the weeds to get SMCT on that case.
DJ Rock, my rater lumped all of my ratings in together to grant my TDIU. What form would I use and how would I go about trying to get the VA to separate out one of those ratings so I could apply for SMCS? So I have seen this before, and it is difficult to do, but like, let's say you have 70% for PTSD but they lumped in everything. It also depends on what you put on your 8940 form, because if you put all service connected conditions, they're going to do all service connected conditions. If you put just PTSD, then they should only do PTSD, but who knows if they actually do that. But you would need like a vocational expert or someone to say that just because of that one condition, you are unable to work and you can't sustain gainful employment. I don't think there's a specific form you would use. What is your comments on that, Kerry?
Well, as far as the form goes, I guess you could probably use a supplemental claim form.
Yeah.
Like that. Yeah, I know. I agree with Allison, but at the same time, I have to be skeptical here. You're reaching for an additional, couple of $100, maybe $300. And are you going to get it? Are you putting yourself in danger? Are you protected at the current rate? I mean, all those same questions I would still have to ask. You know, are you going to be able to show one specific disability by itself as causing TDIU? Yeah, I mean, that's very, very case specific, obviously. But yeah, I'd approach with caution.
Absolutely. It's definitely not worth losing your
No.
TDIU just because you're trying to get the SMCS.
One way to look at it is, you know, the difference between 90 and 100 is, you know, well over $1,000. The difference between 100 and SMCS is just max maybe $300. So, you know, you only have to go down one rung to lose $1,000. You have to go up one big step just to get an extra $300.
Michael, do attorneys get paid to reopen a claim on a supplemental 0995? So this is actually a recent case that came back down that attorneys can get paid on reopening a claim for the supplemental, because if you're reopening something that you have already claimed in the past, it has been denied. So in a sense, you kind of are reopening that appeal. You're appealing that denial, but not really appealing, you're reopening it. And then the other way you would use a supplemental claim is if you're filing it within a year of an already open decision. So yes, attorneys can get paid to reopen claims, especially like Blue Water Navy claims, things like that. DN, how do I nexus ED to PTSD meds as aggravation secondary? A lot of people claim ED secondary to PTSD. It could be due to the medications, or it could just be due to your symptoms of PTSD, but that's something that you would need a doctor's medical nexus on to show that because of your symptoms or because of side effects from the medication, it causes the ED. Okay, Michael Miller, hello. I am claiming multiple claims for PTSD, chronic back pain, degenerative disc disease, and anxiety. I have plenty of notes via military doctors, and I have buddy statements. Do you recommend anything else? Go ahead, Kerry.
Well, I mean, if you've got all that stuff and they have not made a decision yet, I mean, it sounds like you've done your homework. If you've gotten that you're ahead of the game on compared to most cases, put it that way. Without knowing more facts about it, you know, I think it would be really hard to say if you need more information, but it sounds like you've got the right information already. So I might let them make a decision, see what happens.
Okay, let's see. We got to wrap it up soon. Let's pick a few more. Anthony Baccarelli. I am service connected for diabetes. Now I have one kidney is only working 20%. Can I claim secondary from diabetes? Absolutely. I mean, if the diabetes are what caused your kidney condition, then you can definitely claim it secondary to. Kidney conditions are usually inferred in the DBQ that if you do present with kidney conditions, they're supposed to review that as well. But if not, you can go ahead and do a secondary claim for that. I would claim it kidney condition secondary to diabetes, and that would spark a C&P examination. They may grant it, if not, but always, I would say, get your outside provider to give a nexus opinion if possible.
If I could add a word of caution on that one. One thing that gets a lot of those denied is if the veteran has, say, longstanding hypertension. Hypertension is a kidney killer, right? Especially if it's longstanding and it's untreated. If you had that for a long time before you became diabetic, I can't guarantee it, but I could, you have a pretty high chance that the VA examiner is going to latch onto that and blame the kidney problem on the hypertension, maybe rightfully so in some cases, that then predated the diabetes, resulting in a negative opinion. So think about your situation. If it's like that, you might want to prepare for that first and rather than just going out and let VA get an opinion. Like Allison said, seek something out first yourself. They've got to get the ball shifted into kind of your court there.
J Rios 631, should I start getting treated for the ailments from VA concerning what I have claimed? Does it matter after the fact of me claiming to get treated? Thank you. Absolutely. I mean, you have to show that continuity of care, that you continue to have these conditions and that you're receiving treatment for them. It doesn't have to be through the VA though. I mean, you can get treatment through private providers, but continuing to show that care is great. But if you have that gap between when you filed and your service, definitely do buddy statements and statement from yourself to show that you continuously had those issues. Any comments on that?
No, nothing more to add on that, I don't think.
Let's do one more. Let's see. Ooh. How do I get a copy of my redacted C file? Are C files I mean, what would be redacted? I would think maybe your service records, if there's things in there, but your C files are normally just your C file, right?
Yeah, what you might see redacted sometimes if they've got service records and it's got other service members' names on there and their socials. Orders sometimes will come down with a whole list of people's names on there, including their socials. But if that's in just one veteran's claims file, the rest of that stuff is technically somebody else's private information. So they could redact, and they should redact stuff like that. But apart from that, no, if you get your own claims file, it should not be redacted. And that should also include the VA employees' names, although I've seen plenty of them redact those names. And to some degree, they've got some, well, you shouldn't redact it, and some people don't care. At some point, you got to think of what kind of employee it is. So if it's a VBA employee versus a VHA employee, I mean, doctors' names are going to be in medical records. They're not going to redact those. But with a VBA employee, you might get a redaction if it's just a regular line employee, because those guys don't have the position to put themselves in a public light. That probably doesn't make sense. But picture an RO director or an assistant director or a service center manager. They're in such a senior leadership role, they're expected to be quasi-public figures. So their names typically don't get redacted from something like that. And so there's the difference there. But no, I typically wouldn't worry about getting a redacted copy of your claims file. Just get a copy, if that makes sense.
Okay, let's finish it off with DADS-ED, because we see this all the time, and it's different for different errors. HLR found errors. What's next, or what should I do? So it depends on what the error is. Sometimes it's for a new medical opinion where they have to request for them to a new medical opinion. Sometimes it's for new examinations, which you'll know more about because they're scheduling you for the exam. Sometimes it's for federal records, which can take months and months and months. Sometimes it's for Social Security records. One that I see is request for JSRRC, which that's not what it's called anymore, but the Joint Service Record Center, where they go and try to corroborate that things happened. I have some of those in duty to assist for over 2 years. There are extreme delays in these areas, and there's not really anything we can do about it. The only thing I would recommend is, if you know what they're trying to get, and it should say it in your rating decision, and you can go out and get it, then I would go out and get it and put those into your record. But there's not really anything that you can do. You just wait for them to fulfill the duty to assist, whether it's getting you a new exam, a new opinion, or getting whatever records are requested. Anything else, Kerry?
No, I don't think so. I know exactly what you're talking about with that 2-year wait on Jesuit records. That's, if any of you are familiar with that, VA took over that role from DOD. It was a DOD office. VA did not staff it up very good. And then VA started becoming so over-inclusive in what they included in those record searches They're doing record searches for people that don't need record searches done, period. I mean, at all, and they're doing them in mass. And it's just slowing the process down tremendously for everybody else. I brought it to VA central office's attention. I have not seen anything anything about it. Anyone do anything about it yet, which is disappointing. But you know, VA's getting good at disappointing here lately.
Absolutely. We're just as frustrated with that, and we're doing whatever we can, but our hands are tied a lot waiting for those records. And majority of the time they don't find anything.
Right.
Okay, so we're out of time for today, but we appreciate you all watching. Make sure to leave a like and subscribe if you want to see more videos. And if we didn't get to your question or you want your question answered next time, go ahead and put it in the community section. We appreciate you all watching and participating, and we'll see you